We have breaking news. We are getting new details from court after former FBI Director James Comey pleaded not guilty to federal charges. He's facing 1 count of false statements and 1 count of obstruction of a congressional proceeding. Now, his attorney is asking for a jury trial. I want to bring in Washington Bureau Managing Editor Catherine Faulders at the Alexandria Federal Courthouse and ABC News legal contributor Brian Buckmeyer for more. Hi to you both. So, Catherine, what's the latest here?
So we do know that the judge has now set this trial for January 5th. That's what he said inside the courtroom. It didn't appear that there was any objection to the government when the judge set this trial, even though the government did say the case was, quote unquote, complicated. Pat Fitzgerald, a lawyer for Comey, said he didn't view the case as complicated. Now, Comey's team originally said they wanted a January 12th trial date. There was some discussion about this being in December. They ultimately settled on January 5th. So at this point, it seems like that is going to be the case. Of course, we'll likely see some motions and filings between now and then. And I think both sides have a lot of work to do here. I'm reading the handwritten notes from our team inside, Nicholas Kerr, Laura Romero, and Emily Chang. They said that the government was asked by the judge how long they think that this trial will last. They said 2 to 3 days. That's what the government said. So they would only need 2 or 3 days for this trial that is set, of course, to begin on January 5th. Now, I will say when Comey entered his plea, he didn't enter it himself. His lawyers entered the plea for him. Comey stood, of course, as the judge read his rights. The judge read Comey, as a judge typically would, both of these charges that he's facing that you mentioned inside the courtroom. He said that the penalties are up to 5 years and a $250,000 fine. The judge asked Comey if he understood the charges against him, and he said, I do, Your Honor. They waived the reading of the indictment, which they typically do, so they didn't have to read the indictment in there. But I just also want to point out that Lindsey Halligan, the new U.S. attorney that was just previously Trump's defense attorney, is inside the courtroom along with 2 prosecutors from North Carolina. That's because they couldn't find anybody in this office, in this U.S. attorney's office, who would be willing to prosecute the case. So they found 2 lawyers who came up from North Carolina to make the initial appearances in court. As far as we know, this hearing is still ongoing. Comey is seated inside that courtroom in between 2 of his lawyers. So we'll see what other news comes out of this. But what we do know at this point right now is that the judge has set a January 5th trial. And it doesn't appear, at this point, I should say, to be any objection to that date from either the government or Comey's defense attorneys.
Brian, what do you make of the strategy of asking for a jury trial here?
I think asking for a jury trial is smart for a number of reasons. One, you're in Alexandria, Virginia. That, I think, based on voting practices, leans a little bit more left than it does right. So you're hoping the population understands and sees the dynamics as playing out outside of the court and might be beneficial for the defense. Also, this isn't about a technical or legal argument that you're making. I think what you're asking a jury or a finder of fact to do is to evaluate the validity of someone's statements, to see whether or not you believe this person. And if you're the defense attorney and you're already hearing that there are at least 1, if not 2 witnesses who are undercutting the government's position, then you want a jury or at least a group of peers to look at this and say, all right, this doesn't line up. The circumstantial evidence that the government is trying to portray as to why this was a lie doesn't line up. And I say circumstantial because at least at this point, if there's a difficulty in this case, there's probably not direct evidence that Comey lied.
You mentioned sources say at least 2 potential key witnesses have undercut the government's case here. Other prosecutors refused to bring these charges, citing a lack of evidence. And yet, the grand jury did hand down this indictment. So where does that leave the prospects of a trial?
So I would say it's somewhat left up in the air because ultimately the 2 things that I think of before we get to a trial is there going to be a legal argument as to why this case should not move forward? And then the second big one when you have witnesses undercutting is how are you going to get these witnesses to come in and testify in a manner in which you believe can secure a conviction? Now, to the latter, they can have subpoenas compelling individuals to come in under threat of incarceration or prosecution. I think that would probably be what happens if these witnesses do not want to come and testify. And if they are found to be adverse witnesses and they have to be cross-examined rather than giving information willingly, how does that play out in front of the jury? I think we could potentially see a jury trial, especially because it's so soon. January 5th is right around the corner, especially when you talk about a federal federal prosecution. But the motion practice that will happen before then could potentially push it back in terms of trying to get through the nitty-gritty as to how this case will actually be proven or argued at trial.
What would it take for the judge to decide there's not enough here to go to trial? How high is that bar, given a grand jury did hand down this indictment?
So judges hesitate to take a case outside of the jury's hands, even if there is not a jury as yet. What will likely happen if the judge is to dismiss this case, it will be because the grand jury was improperly impaneled, improperly given information, improperly voted on this case. It would be not on the facts or the merit of the case, but on a legal standard that was not reached when the grand jury was given this information and came to this decision. I can't see another legal reason why the judge would take this case out of the hands of the jury, other than perhaps a vindictive prosecution, which is a high bar and a difficult one to reach. I think the judge could hamstring the prosecution in some way, shape, or form if there's not the evidentiary backing as to why certain evidence should come in, namely, how are you proving what was in James Comey's mind at the time in which he made this statement if you do or do not have corroborating information?
And Catherine, you're getting more notes from the courtroom?
I am. Our Laura Romero just ran out from the courtroom, and quite a bit of news here in what she just passed on. So Comey's main defense attorney, Pat Fitzgerald, says he will be filing a motion to challenge the appointment of Lindsey Halligan. Of course, that's the U.S. attorney here, Trump's former defense attorney, who he put in to, frankly, go after and indict people he perceives to be his political opponents. So they will be challenging Comey's team, will be challenging her appointment. They didn't get into what exact rationale they will use in that motion to challenge her appointment, other than said to the judge that that is something that they would be filing. Now, the judge did say that any motion to disqualify Halligan from this case will be heard by another judge. Obviously, that's the process. This judge will not hear that. But they did set a briefing schedule for the first tranche of motions. So the next time it appears at this point that we will see the parties in court will be on November 19th. And on December 9th. So that appears to be the next time that Comey will be in court. Now, there was an interesting back and forth about Pat Fitzgerald, the attorney, the main attorney who's representing Comey. He's going to need a security clearance for any classified information that may or may not come up here. Classified information and leaking classified information is not really what's at the heart of this case, but he nonetheless will need a clearance with all that discovery that he will likely get from the government to review. Now, Pat Fitzgerald preemptively said, I think this is interesting covering these classified documents cases, he said, quote, there should be no reason why this case goes off track because of classified information, almost anticipating that the government might try and delay because of the review and the process that is needed to get a security clearance and then is needed to give that classified information to him to view in a secure setting. Now, the government said they're not seeking detention, Diane. The judge then said he will place Mr. Comey on personal reconnaissance bond. And I'm just getting a note from our Nicholas Kerr from inside the court that says this hearing is now over. That court adjourned just 3 minutes ago. So this is over. This started at 9:55, ended at 10:23. So that is where we leave it. And we do expect both of the parties, again, if nothing else is scheduled by this judge in the meantime, which is quite possible, to appear here in court next month on November 19th for hearings on these motions. Judges can rule on motions without scheduling hearings. This judge indicated that he would have hearings. And again, this motion to disqualify Halligan from the case will be heard by another judge in this court, not the judge overseeing this trial.
And we're watching now to see if James Comey decides to speak outside that courtroom. Brian, how is classified information usually handled in court?
So it's not usually handled in court. For the most part, it's handled outside of the court or outside of the presence of the public or the audience. If there is classified information, and I agree with the attorney Fitzpatrick, I can't see where this would be an issue because at the heart of this case is whether or not James Comey misrepresented or lied and obstructed justice, not necessarily about classified information, but about information that became privy to all of us when that information came out. But in terms of how it usually operates is if the attorney doesn't have access to it at the beginning of the case, because they're not that attorney who typically handles this, they're given access from a limited standpoint that is enough to be able to represent their client. They view that with the DOJ in a private setting. They're oftentimes not given the documents, for example, to take home, but they kind of look at it in a private room, and then they use that to zealously advocate for their client.
All right, Catherine Falders, Brian Buckmeyer, thank you both.